All right. Good afternoon, ladies and gentlemen. My name is Judge Law, and we're going to begin with our expedited accusation calendar for today, April 25th, 26th, sorry, April 26th at 2 p.m. These are misdemeanor cases in which individuals were recently arrested and booked at the Fulton County Jail. Soon thereafter, the cases were formally accused by the prosecutor, which is the Solicitor General's Office of Fulton County. This would be the defendant's initial appearance before a judicial officer. I will let you know what your accusation number is, what are the charges that have been brought against you, to appoint counsel to represent you if you cannot afford your own attorney, and or if you do not have one at the present time, and also to set a bond. Some of you may receive what we call a signature bond, and that's one in which you would not have to pay for the bond today for your release, but you would have to comply with certain conditions. Failure to comply can result in a revocation of the signature bond. Others may qualify for what we call a surety bond or a cash bond, and that's the one in which you would have to pay for the bond in order to secure your release, either out of your own pocket or through a bonding company. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court during the course of this virtual proceeding that is not only recorded but live streamed, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Courtroom 2, who do we have, please?
Position number 1, Japal Adams.
All right. Mr. Japal Adams, case 24CR 2289J, is accused of battery, family violence from March 16, 2024. Mr. Adams, you have been advised of your right to remain silent, and your attorney is Mr. Cook. Is that you?
Yes, Your Honor.
All right. Any priors, Mr. Howell?
17. Theft by taking, burglary, smash and grab, dismissed from 2023. That was out of Whitfield County. 2021 burglary, smash and grab, conviction on probation for that out of Bleckley County. Also on probation out of Floyd for RICO and burglary, and that goes into 2036. 2021 FTA and the 05 armed robbery conviction.
Thank you. Mr. Graham?
Good afternoon, Your Honor. This incident took place on March 16, 2024. Law enforcement responded to a dispute call at 931 Pinehurst Terrace Southwest in Atlanta. Upon arrival, Jonathan Adams advised that a disagreement with his mother prompted her to tell him to leave the residence. He agreed to leave, but told her he had to gather his belongings first. His mother then called his brother, Japal Adams, and who told him then he needed to leave immediately. Japal went into Jonathan's room, which is a basement of the house that has a separate entrance. Jonathan followed him, told him not to touch any of his stuff. At that time, Japal turned around, punched Jonathan several times in the face, resulting in a bloody nose and a swollen lip. Japal fled the location before law enforcement arrived. Our office has not been able to get in touch with Jonathan, Your Honor, but based on the history, Mr. Adams has a clear disregard for other people's things and their persons, tendency toward violence. State is recommending a $1,500 surety bond, 1-day anger awareness, no further contact with Jonathan Adams, a stay away from 931 Pinehurst Terrace Southwest, no alcohol, drugs, or weapons. And if we may sound for Jonathan Adams at this time, Your Honor.
All right. Mr. Jonathan Adams. All right. Mr. Cook?
Your Honor, my client is 41. He's lived in this area, the Atlanta area, his entire life. He is gainfully employed. It's my understanding from my client's comments that the alleged victim, and we use alleged seriously, does not live at 931 Pinehurst Terrace, and my client denies the allegations as stated in the warrant. So we don't feel there's any need for a stay away. We would object to the anger management, and we would be seeking a signature only bond through to whatever level the court deems appropriate.
All right. Bond is going to be set at 3,000. It's going to be a signature bond through pretrial services. It's just going to be level 2. No further contact with Jonathan Adams. He may return to the 931 Pinehurst Terrace location only if Jonathan Adams has vacated the premises. So if he goes back, he's allowed a one-time visit with a police officer to verify that the place has been, that Jonathan Adams has vacated the premises, then he may return to that location. Otherwise, he would need to update the court with his new mailing address if Jonathan Adams still lives there. No illegal drugs, no alcohol, no weapons. And Mr. Japal Adams, you're already on felony probation. If you violate the conditions of this new bond, or if you get arrested again, or if you don't appear for pretrial or report to court, your signature bond will be revoked and canceled. Please remember, you cannot stay at 931 Pinehurst Terrace unless Mr. Jonathan Adams has vacated the premises. If he has not, then it's up to your mother to file a dispossessory action. You cannot live there, and you have to give us a new address. Thank you.
That's per judge.
Next,
Judge-
condition number 6.
Excuse
Thank
me,
you,
Judge,
ma'am.
what was that amount?
3,000 signature bond through pretrial, Ms. Grace.
Your Honor, I have a private attorney, Miss Attorney Ryan Swartz, and his client is here at ACDC, position number 2, Miss Bader.
All right, I'll be right with position number 2. Give me a moment. Position number 6, I have Lawana Johnson, accused of battery from August 26th of 2023, case 24 CR 2298F. Ms. Lawana Johnson, you've been advised of your right to remain silent, and your attorney is going to be Miss Atay. Any priors, please?
2024 FTA. 2023 ag assault weapon open out of Denver, Colorado. 2019 terrorist threats NOLO. 2020 trespass conviction.
Okay. Ms. Stafford?
Yes, Your Honor. This incident occurred on August 26, 2023. At approximately 9 o'clock p.m., officers at the South Fulton Police Precinct made contact with the victim, Ms. Chiquita Westfield, when she came into the precinct regarding a physical dispute involving the defendant. She advised that she had been severely beaten by her father and the defendant, who was her aunt. And she stated that at that time she was located at 255 Emmett Court. She advised the police that her grandmother was actually the person that ordered the defendant and her father to attack her, and they punched and kicked her in the head, neck, and back area. She informed the officers that after the attack, she was able to flee the incident location and go to her mother's house, who subsequently brought her to the precinct. The officers did observe several bruises and scratches on Ms. Westfield's face, back, and neck. In addition, she had a cut in the inside of her lip. Due to the defendant's history, including the open ag assault, the state at this time is asking for a $5,000 surety bond, anger awareness, no further contact with the victim, Ms. Chiquita Westfield, a stay away from the incident location, which is 255 Emmett Court. And at this time, the state will ask the sound for the victim, Ms. Chiquita Westfield.
All right, Ms. Westfield, if you're on Zoom, you need to unmute and start your video. All right, Ms. Atay?
Yes, Your Honor. My client is 49 years old. She has lived in Georgia all her life. She firmly denies the allegations here. This allegedly occurred August of last year. The complaining witness does not live there. She states that this is the niece or her niece, and she lives there at Emmett Court with her mother, and states that the niece will come and cause a lot of disruption in the home, take over the home, is disrespectful to her mother. And she states that the complaining witness was the first aggressor. Obviously, the grandmother of the niece was, asking for help, but my client denies the allegations, and again states that the complaining witness was the first aggressor. I would ask for a signature bond through pretrial services. No further contact with the complaining witness is fine. But I would object to a stay away. The complaining witness does not live there, Your Honor. This happened August of last year.
Bond is set at $3,000, is a signature bond through pretrial services, level 1. No further contact with Trokita Westfield. She may return to the location as long as the victim does not live there. She would have to return first time with a law enforcement officer to verify that Ms. Westfield doesn't live there. She's report to pretrial once a month, and if she gets arrested again for anything else, this particular bond will be revoked. Unfortunately, Ms. Johnson also has a $2,000 surety bond on a FTA in case 19 CR 7731F. So she would need to address that particular matter before the judge, I guess Judge Richardson. This case is both cases are going to be reset to May 9th because of that FTA bond.
This per judge too.
Yeah. Thank you. Position 2, we have Alejandra Bader. Is that your client, Mr. Schwartz?
Yes, Judge. Thank you very much.
Your case number is 24CR2290Y. She's accused of battery from April 24th, 2024. Ms. Bader, you've been advised of your right to remain silent, and your attorney is Mr. Schwartz. Any priors, Mr. Howard?
Second, 2017 DUI.
Mr. Grant?
Thank you, Your Honor. This incident took place April 24th, 2024. Law enforcement responded to a domestic dispute at 7610 Highland Bluff in Sandy Springs. Upon arrival, Emily Williams advised that her aunt, Alejandra Bader, bit her on the right arm during an altercation. She explained that she was in the bathroom when her aunt forced her way in, attempted to take her cell phone. She tried to push her aunt out of the bathroom, tried to keep her from taking the phone. That's when her aunt bit her on the right forearm. The two do live together at that location. Your Honor, up until court, we have not been in touch with Ms. Williams. I see she is logged on. The state is requesting a signature bond through pretrial services, 1-day anger awareness, no further contact with Emily Williams, a stay away from the incident location, 7610 Highland Bluff, no alcohol, drugs, or weapons. And of course, we'd like to sound from Ms. Emily Williams at this time.
Emily Williams, if you're on Zoom, please unmute.
Hello.
Hello. Ms. Williams, do you still reside at the Highland Bluff location?
Yes, ma'am.
Right. And how do you feel about contact with Alejandra Bader?
I have a really, really good relationship with my aunt. It was a mistake. We had both been drinking that night.
Okay, I'm sorry. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? So both of you were drinking, and then what happened?
We were arguing about petty stuff about work and whatnot, and what was said earlier, she came in the bathroom, tried to take my phone away, and that's when the incident occurred.
All right. Thank you. Mr. Schwartz?
Yes, Judge. Thank you very much. Ms. Bader is 36 years old. She has been involved in the Atlanta legal community for many, many years. She is the president of her own legal consulting company. Ms. Williams, her niece, actually works for her and has graciously allowed Ms. Williams to live with her. She has no, as you heard, she has no priors, other than a DUI several years ago. She has significant ties to the Fulton County, Sandy Springs community, including her daughter, her parents, her siblings, nieces, nephews, a lot of people that are in support of her. We would ask that the court set a bond, but we would also ask, based on the fact that Ms. Williams is here and has testified, that you make the condition from no contact to no violent contact. Again, Ms. Williams is an employee of Ms. Bader's consulting company, ABS Consulting. And again, she does live with Ms. Bader. So we would ask that that arrangement still be allowed to continue.
$2,000 signature bond through pretrial services, level 1. No further violent contact with Emily, was it Williams or Williamson? Williams. Also, Miss Alejandra Bader is to refrain from all alcohol consumption. She may be subject to random screens by pretrial when summoned. Her next court date will be sent to her current address. If Miss Bader wishes to have Miss Williams leave the property they share, she would need to file the necessary dispossessory action unless Miss Williams voluntarily vacates the property. Thank you.
Thank you, Judge. May I be excused?
Yes, Mr. Schwartz, thank you.
Thank you, Judge.
Next, we go to position number 3, Mr. Michael Brown.
Your Honor, before you go to number 3, FYI, I'm gonna leave and come back, okay?
Okay, FYI, got it. Thank you.
Right.
I'm sorry, courtroom 2, who was the, what's the case number of the person? Courtroom 2?
Position number 3. Mr.
3, okay, sorry about that, okay. This is Michael Brown, accused of criminal trespass from April 25th, 2024. And Mr. Brown is accused of this criminal trespass in case 24 CR 2291F. Mr. Brown, you've been advised of your right to remain silent, and your attorney is Mr. Cook. Any priors?
25. You got an open trespass in state court. On probation for robbery. What else? Couple of probation violations from 2023.
Mhm.
2023 trespass, 2022 reckless conduct conviction.
That's good. Thank you. Mr. Graham, what's the state's recommendation?
Your Honor, in this case, Mr. Brown was found lying inside of the Red Roof Inn at 4430 Frederick Drive Southwest. The building is abandoned, no longer open for business. It's currently the property of Fulton County. The state is recommending a signature bond through the jail, Your Honor, and stay away from the incident location. No alcohol, drugs, or weapons while out on bond.
All right. Mr. Cook, your client's bond is $1,000. It's a signature bond through the jail. He cannot return to that location. The Red Roof Inn, I'm sorry, I didn't catch the address.
4430 Frederick Drive, Southwest Atlanta.
4430 Frederick Drive, Southwest Atlanta. Mr. Brown, you're going to be released again on a signature bond. This is your second trespass case that is open with the State Court of Fulton County. Please make sure that you provide us with contact information so that you remember to show up in court for both cases. If you don't, a bench warrant will issue, and that will result in you staying in jail until your cases are heard.
Yes, ma'am.
But you cannot return to this Red Roof Inn, even if it's empty and just a vacant shell of a building. That building still belongs to someone else and not you. So you cannot return to that property at 4430 Frederick Drive. Otherwise, we will roll out the red carpet for you again. Thank you.
Thank you, ma'am.
Next, we go to position number 9, Mr. Robinson.
Hey, bro.
Orlando Robinson's case is 24 CR 2297C. He's accused of battery, family violence from April 25th, 2024. Mr. Robinson, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Any priors, Mr. Howard?
31. He don't have any violence, at least in the last 15 years that I saw.
All
He
right.
got some before that, but it's real old.
All right. And he's about 62, 63. Ms. Grant, Ms. Stafford?
Yes, Your Honor, this incident occurred yesterday. Officers were dispatched to a dispute call at 899 Park Street Southwest, apartment 203. And upon their arrival, they spoke to the victim, Ms. Cheryl Brown, who advised that she had been assaulted by the defendant. She stated that the dispute began after she had finished making dinner, and she was talking to her brother, Mr. James Bradford, when the defendant became upset and started to curse her out. At which point she stated that the defendant, she told the defendant that she was speaking to her brother, and he stated, quote unquote, "I'm tired of this shit," and grabbed her by her arms, causing bruising. He then proceeded to throw her on the couch, and when she tried to get up, he grabbed her again. At that point, Ms. Brown stated that she had grabbed a leg crutch in order to keep the defendant away. However, he grabbed it and put it down. He then proceeded to grab her arm and slapped her on the right side of her face. When she got up that time, she grabbed a bottle of cleaning spray and sprayed it in the air to maintain some distance as she backed away. She eventually backed up so far that she was outside of the apartment, at which point the defendant locked her out. Her brother then unlocked the door and let her in, at which point the defendant grabbed her again and struck her again. Officers did speak to the victim's brother, who did confirm the victim's side of the events. Our office has not had any contact with Ms. Brown at this time, and due to the fact that this just happened yesterday, the state is asking for a $3,000 surety bond. Anger awareness, stay away from the incident location, no further contact with the victim. And at this time, we would like to sound for the victim in the event that she is present.
All right. So Cheryl Brown is not related to Mr. Robinson. They are intimate partners?
Yes, Your Honor.
Okay, and Cheryl Brown's brother happens to be an eyewitness. Is that what you're saying?
Yes, Your Honor.
Okay, thank you. Ms. Kim?
Yes, Your Honor. My client is 61 years old and he's still working, doing landscaping, and it's kind of like an odd job. It's not stable, so he's still qualified for public defender services. He graduated from, he didn't graduate from high school. He has a GED, and Your Honor, he does not have any MH issue or anything, any issue except that he has a hard time walking. My client denies the allegation completely, and he says he was just defending himself when Cheryl Brown, who was drinking, was about to attack him with a leg crutch. And of course, James Brentford, the eyewitness, is brother of the alleged victim complaining witness. So it's very biased.
Yeah.
So we would like to request for a signature on bond through pretrial level 1 and no further violent contact. They do live together, and my client does not have any other place to go.
What? This is 899 Park Street. Okay.
Yes.
All right, Mr. Robinson, your bond is going to be set at 2,500. It's going to be a signature bond for pretrial services level 1. You'll have to report to pretrial once a month. You are to have no further contact with Cheryl Brown. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. You're also to stay away from 899 Park Street in Atlanta, Georgia. You may return to that location one time only with a police officer to retrieve your belongings, and then you will need to update the court with your new address within the next 30 days from your date of release. Please remember to report to pretrial once a month and maintain a current address with the court so that we can send you your notice to appear next time. But you cannot live at 899 Park Street. You would need to update us with your new address. Thank you.
Next, we have position number 10, Christopher Strong.
Christopher Strong is accused of simple battery family violence from April 9th, 2024, and the case is 24 CR 2295D. Mr. Strong, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Any prize, Mr. Howard?
2023 terrorist threats, simple assault, criminal damage to property was the last. 2017 FTA, 2016 ag assault, criminal attempt to commit a felony, possession of a knife or a firearm during the commission, criminal street gang activity. That's all one arrest conviction.
All right.
2015 robbery, first offender. 2014 battery DV, first offender.
That's good. Thank you. Ms. Stafford?
Yes, Your Honor. This incident occurred on April 9th, 2024. At approximately 6:46, officers were dispatched in reference to a physical dispute to 226 Grove Place, apartment 46 in Roswell. Upon their arrival, they spoke to the victim, Ms. Shaquita Williams, and she stated that the defendant is her husband and he hit her in the face 3 times on the left side of her face. She told officers that she and the defendant were arguing over house keys. She said that the defendant was leaving the residence and he had the only set of keys and would not give them to her. The victim's children were present at the residence at the time. And upon speaking to one of the children, initial CW, that child stated that she saw the defendant push the victim's head while they were arguing. Officers were not able to see any bruising or swelling on the victim's face when they observed her. Due to the fact the defendant does have violence in his history, state is currently asking for a $2,000 surety bond, anger awareness, no further contact with the victim, stay away from incident location.
All right. Ms. Kim?
Yes, Your Honor, my client is 26 years young and he has been here in Georgia for all his life. And he does have another place to go. He actually moved to his mom's place, so he does not have to return back to incident location. And he prefers to have no further violent contact. However, if Your Honor is not inclined to give him a no further violent contact, he is okay with no contact and stay away. Your Honor, he just has to go there one time to retrieve his car and his personal belongings, which right now complaining witness has. So this happened on April 9, even though there has been ample cooling off period. I think my client is okay with any decision you make. They are legally married. However, my client says he's looking for a divorce right now, but they do have 2 children together and 2 years old and newborn baby. So he prefers to have a third-party transfer for children. He is gainfully employed. He drives for car parts. He does delivery, and his wife does not have any job. But he graduated from high school. And that's about it, Your Honor. We would like to request for a signature on bond through pretrial, even though level might be number 3.
Okay. Is Shaquita Williams on Zoom? All right. Bond's going to be set at $2,500. It's going to be a signature bond through pretrial services, level 2. Which means, Mr. Strong, you'll have to report to pretrial services twice a month. You're not to consume any alcohol, you're not to consume any illegal drugs, and you're not to possess any weapons and any firearms. You will be subject to random screens for drugs and alcohol, and if you fail a screen, you could end up being back in jail. You have to have no further contact with Shaquita Williams and no contact with the minor children unless you file a domestic divorce action and obtain a court order for temporary visitation or custody of the children in question. So at the present time, there should be no contact with Shaquita Williams and the children unless there is a temporary Superior Court order establishing temporary visitation and custody pending a divorce. I am not inclined to let you return to the location to retrieve belongings because you are married to Miss Williams. So if there's going to be any separation of property, if there's I don't know whose vehicle is whose, so I'm going to let the Superior Court allow you to determine what property you may retrieve. Miss Kim, I understand from you that he's moved out and he's moved to his mother's place since April 9?
Yes, Your Honor.
Okay, so no, I'm not going to allow him a one-time visit. He cannot retrieve any vehicles and he cannot retrieve any property from the marital home unless there's a divorce action and there's a court order allowing him to obtain certain property. Because I don't know whose vehicle is whose. If there's only one vehicle, then it's going to be for the victim and the children. All right. His next court date will be sent to his new address, and we don't have that. What's his new address?
I actually do not have it yet, Your Honor.
All right, we only have the Grove Place, and that's the address where the victim lives, so we gotta have a new address. Mr. Strong, you can either give your new address to the deputy there, or you can tell it to us.
It's 12297.
11
12297
1229
7
7
Riviera RIV Riviera Drive. And that's Fayetteville, Georgia.
I'm sorry, where?
Fayetteville, Riviera.
Fayetteville, Georgia.
Yes.
All right. And is there an apartment number or room number?
It's a house.
All right. So please understand that if you plan to get any property or you wish to see the children, you need to file a divorce case. Thank you.
How much was that?
2,500 signature bond, level 2, free trial.
That is per judge.
Yes, sir.
What is this?
Next case, please.
We go to position number 5, Tremaine Jefferson.
This is State versus Tremaine Jefferson, 24 CR 2293Y, accused of battery, family violence from April 18th of this year. Mr. Jefferson, you've been advised of your right to remain silent, and your attorney is going to be Miss Atay. Any priors, please?
Second, 08 battery DV, battery, possession of marijuana, dismissed out of Clayton County.
Right. Mr. Grant?
Thank you, Your Honor. This incident took place on April 18, 2024. Law enforcement responded to a domestic dispute at 3085 Duke Drive in Fairburn. Upon arrival, Jonte Jameson Jefferson advised that she was physically assaulted by her husband, Tremaine Jefferson. He became angry for an unknown reason and sat on top of her. He then stuck his finger in her mouth, pulled her by the teeth, pushed her by the neck before slapping her in the face. The officer observed hemorrhaging in her right eye as a result of the slap. She further advised that she has a protective order against her husband, but she invited him back into the home because they were on seemingly good terms in working on their marriage. Our office has been in contact with Miss Jameson Jefferson, Your Honor. She says they've been married for about 10 years. They have a 7-year-old daughter. They do reside at the 3085 Duke Drive address. She stated that Mr. Jefferson has been verbally abusive to her in the past, but this was the first time he's been physically abusive to her. The temporary protective order was taken out in March due to the verbal abuse. And then they decided to work things out, and he moved back in. She confirmed the events in the warrant. She believes that he's under some stress. This is not his usual behavior. She would like no violent contact and anger awareness, and she's okay with him returning to the residence. Your Honor, we were unable to determine I know that battery from the violence arrest was back in 2008, but I couldn't find the victim. And based on the temporary protective order that is in place, we are going to still ask for a no further contact with Jonte Jameson Jefferson and a stay away from 3085 Duke Drive in Fairburn. Your Honor, I do realize that Mr. Jefferson was arrested on April 23rd at 12:30 p.m. So we may have a possible Riverside. We'll ask for a signature bond through the jail. One day anger awareness and no alcohol, drugs, or weapons. Your Honor, I do believe Miss Jonte Jameson Jefferson is on Zoom if we may sound for her at this time.
Miss Jefferson?
Yes, ma'am.
All right. You raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And what is your protective order case number?
That I do not have pulled up. I can pull it up.
Yes, please do pull it up.
But as stated,
Pull it up. Pull it up.
Give me 1 second. Let's- 1 second. Is it at the top of this? The file number is 24CV003264.
Please hold.
I'm sorry.
Hold, please. Yeah. All right. There is a current 3-month protective order issued on April 9th. So this occurred on April 18th. And it's a 3 months, so May, June, July. This order ends in July 9th, 2024. And let me see. Signed by Judge Osby. And I don't see where this case has been dismissed or amended or anything to that effect. Okay, thank you. Ms. Ate, anything to add?
Yes, Your Honor. My client is 38 years old. He is the father of 2 minor children. He's lived in Georgia all his life. As you heard, he has no criminal history and arrest in 2008. That was dismissed, Your Honor. He is gainfully employed as a MARTA bus operator. He does deny the allegations as stated in the warrant. This, as the ASG Graham mentioned, this is a Riverside issue. I have no objection to the signature bond through the jail. I would ask for no violent contact. I spoke with the complaining witness and that's what she wants. And of course I would object to a stay away, and I would object to the 1-day anger awareness.
All right. Mr. Jefferson, your bond is going to be set at $10,000. It's going to be a signature bond through the jail. As the matter is Riverside, I cannot impose any restrictions based on the current offense. However, you have an active protective order against you. That order has not been amended, it's not been set aside, and it's not been dismissed. So technically speaking, on April 18th, 2024, you violated the protective order. So therefore, as part of this bond order, I'm going to require that you comply with the conditions of 24 CV 003264. Please note on the last page of the order, since this is considered a violation, if the April 18th, 2024 incident is considered a violation of an active protective order, you can be arrested for aggravated stalking, which is a felony charge, and you could end up in jail for up to 3 months with no bond. Ms. Jamison Jefferson, there's already a court order requiring him to stay away. If you intended to have contact with him, your duty was first to go to the Fulton County Superior Court and get that case dismissed. Instead, you have placed Mr. Jefferson's freedom in jeopardy, where he runs the risk of being charged with a felony offense. So the only requirement right now that I can tell you, Mr. Jefferson, is that you have to stay 200 yards away from Ms. Jamison Jefferson in accordance with the Superior Court order, or you can be arrested for a felony charge. Thank you. His next court date is going to be sent to his current mailing address, and I don't know what it is.
Our home address.
Oh, wonderful. So you're going to send mail to your address where he's already violating a felony or protective order?
No, I was telling you that was his current address. Like I stated, well, I didn't get to say anything, but the judge was aware when we did our court case on April the 9th. She was well aware because it was shared. I'm not sure if those meetings are recorded, but that him and I were trying to make things work. So that was never.
Ms. Jamison Jefferson, I am looking up the case. There is a final order requiring him to stay away. There is, whatever the judge is aware, she never made an exception. So if you want to decide to interpret the order completely different, that's up to you. I'm just letting you know that he has just violated a protective order. So it's up to the district attorney's office to decide whether they want to charge him. Thank you. Next case, please.
Position 11, Carlina Williams.
Miss Williams, Carlina Williams, is accused of terroristic threats and acts. I'm sorry, I got a message. Oh, Miss Grace, yeah, there is the only no contact will be in accordance with the Superior Court order. Did you want the case number again?
Yes, Judge.
Okay, Mr. Jefferson will have to comply with the stay away of 24 CV 003264.
Thank you.
Okay, I beg your pardon. Okay, Miss Williams is accused of terroristic threats and acts in case 24 CR 2296E from April 15th, 2024. Miss Williams, you've been advised of your right to remain silent, and your attorney is Miss Kim. Will that be correct? Is that your client, Carlina Williams?
Yes.
Okay. Any priors, Mr. Howard?
It's her first. She got a hold out of Henry County though.
And what's a hold for? Do you know?
I don't. I didn't make a note of it.
All right. Miss Stafford?
Yes, Your Honor. This incident occurred on April 15, 2024. On that date, officers were dispatched to a disorderly person at 4804 Roswell Road. When they arrived, the defendant was irate and yelling at the employees of Legacy Ridge Elderly Home. The defendant had recently been fired from that location. And when the officers arrived, she did not want to speak to the officers. And she then after left the location. However, prior to the officers leaving, the victim, Ms. Shanika Bennett, stated that she wanted to press charges because the defendant had made threats. When asked what the threats the defendant made and what they were and how they were made, the victim stated that the defendant had stated that she was going to F her up and that she had not seen the last of her. The victim stated that other employees had heard these statements as well. And when the officer spoke to those employees, they confirmed that that the defendant had made prior threats in the same nature as well as the threats on that date. The state understands that this is the defendant's first arrest. However, the state is still asking for a $1,000 surety bond, no further contact with the victim, and to stay away from that incident location.
The hold is traffic.
All right, thank you. Miss Kim?
Yes, Your Honor. My client is 29 years old. She's single and she does not have any children. She has 3 jobs. She's working really hard. One of them is Piedmont Hospital. He's a patient tech and he does have high school diploma. And he indeed, even though she does not, I'm sorry, it's she, not he. She does not have any even though she doesn't have any children, she's the one who financially support her family at back home. So it's very important for her to be financially responsible. She denies the allegation. She was like totally shocked by this incident. It's not the way it is. So, and also, I guess her sister, I think I saw her sister on the Zoom, but anyway, we would like to request for signature on bond through pretrial. We have no objection to stay away and no further contact with any of them.
All right. On the terroristic threats is going to be a $1,500 signature bond for pretrial services, level 1. No further contact with Shanikia Bennett, and stay away from the Legacy Ridge Elderly Home at 4804 Roswell Road in Atlanta, Georgia. She's required to stay 200 yards away from that location and 200 yards away from Miss Bennett, including no communication between her and Miss Bennett in any way, form, or manner. No alcohol, no illegal drugs, and no weapons and firearms. I'm not certain if we can release you due to the Henry County hold. So if the hold requires Henry County to come pick you up, then you can be released to the hold. Otherwise, once you make your signature bond, you are to report to Henry County immediately. At the present time, based on the hold I see, it looks like Henry County is going to come pick you up.
Your Honor, may I speak?
If you want to talk about the hold, that's fine, but
Yes, ma'am, I do. My hold was taken care of this morning. It was paid off. My sister is on here as well, and she has all the information towards that.
all right. Who's your sister?
Her name's Takara.
Miss Takara, if you want to unmute and start your video. All right, we'll take the next case then. Thank you.
Thank you.
Position number 7, Mr. Jimmy Ogletree.
This is State versus Jimmy Ogletree, accused of criminal trespass and causing damage to property on April 25th of this year. Mr. Ogletree, you've been advised of your right to remain silent, and your attorney is Miss Kim. Any priors, Mr. Howell?
Second arrest, 2011 felony obstruction dismissed. That was out of Gwinnett.
Thank you. Ms. Stafford?
Yes, Your Honor. This incident occurred yesterday. Officers were dispatched to 845 Drummond Street Southwest in regards to a damaged property call. Upon arrival, they spoke with the victim, Mr. Rodney Swift, who stated that he physically watched the defendant throw a brick into his vehicle front windshield. Mr. Swift stated that the defendant was involved in a verbal altercation, at which point the defendant picked up a brick and threw it through his windshield. When the officer spoke to the defendant regarding the incident, the defendant stated that he threw the brick because Mr. Swift had harassed him due to his sexual orientation, and he was subsequently arrested. At this time, Your Honor, because this just occurred yesterday, the state is currently asking for a $1,500 surety bond, no further contact with the victim, and to stay away from the incident location.
All right. Ms. Kim?
Yes, Your Honor, my client is 36 years old, and he actually lives right next to that incident location, Your Honor. Rodney Swift and my client, they are neighbors right next door, and he claims for self-defense. He has been actually harassed a lot and attacked by Mr. Rodney Swift a very, very long time, and it was to the point that even that day, he was attacked and threatened. So that's why he was defending himself. That's his defense, Your Honor. And we would like to request for signature on bond through pretrial level 1. He does not have, I don't think he has any history. He graduated from high school. No, he studied up to 11th grade, and he is still pursuing his GED. And right now he's trying to find a job as of now. So because of that situation, he's financially qualified for public defender services.
I'm sorry. The alleged self-defense was the brick was apparently directed at Mr. Swift or directed at the car?
I believe it was directed at the car.
So what's the self-defense portion?
That he was afraid. He just wanted to stop. But he didn't want to, I guess. I do not know the motivation, Your Honor.
Well, I don't understand the argument then, let's put it that way. All right. This is going to be a 1,500 signature bond through pretrial services, level 1. Mr. Ogletree, like I said, I don't understand the self-defense argument. That's something that your defense attorney can clearly present that during the course of a trial. By the present time, you are to have no further contact with Rodney Swift and Rodney Swift's mother. I don't know what her name is, but it's not in the warrant. Unfortunately, you're going to have to vacate 845 Drummond Street in Southwest Atlanta if that location is within 200 yards of where Mr. Swift and his mother reside. You can return to that location one time only to retrieve your personal belongings, and within 30 days, you'll need to update us with the new address. No illegal drugs, no alcohol, and no weapons.
He has no other place to go, Your Honor.
Well, in that case, if he wants to continue living there, then he needs to understand that if he steps outside and Mr. Swift is outside, he needs to turn around and go right back into the location.
Yes.
I mean, that's the only way, because if he's outside and Mr. Swift is outside, all Mr. Swift has to do is call the police. If you want to unmute courtroom 2. Unmute courtroom 2, please. Mr. Ogletree, do you understand the bond order? If you want to continue living there, you need to make sure that you're not visible to Mr. Swift at all. So
But I'm the one who being harassed.
Oh, you're the one who's charged, Mr. Ogletree.
I know because, okay.
And I have no evidence of harassment. And let me just make it very clear to you in case you didn't hear this before. I don't understand the self-defense argument.
Okay.
So if you want to push it, I can make it a surety bond and you can pay for this.
No, ma'am.
Smart move. All I'm saying right now is there is an open active case against you. You have a signature bond through pretrial. You need to report to pretrial once a month.
Okay.
And you cannot be visible to Mr. Swift. I'll allow you to go back to your home, but if he's outside, you are under a court order to make yourself invisible. In other words, you either go back into your apartment or you hop in your car and you drive away. But anytime that he's outside, you cannot be visible to him.
Well, I do have a dog that I do have to allow to,
You can put the dog in the car and go walk him somewhere else.
Okay.
That is the unfortunate consequence of being arrested for a criminal offense.
Okay.
But all I'm saying right now is that if you don't want to come back to jail, you need to report to pretrial, come to court when summoned, and make yourself invisible to Rodney Swift.
Gotcha.
All right. Thank you.
Thank you.
Position number 4, Lindsay Davis.
All right. Miss Davis, if you'll just hold a minute. Miss Takiria, iPhone. All right. 1, 2, 3, 4, 5. You're taking a long time to unmute. Okay.
Because my phone isn't working,
Raise-
babe. That's
Raise
why.
your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. What have you done in terms of Henry County regarding your sister's hold?
So her probation officer wanted me to wait to see what you guys was gonna say.
All right.
But she said as soon as it's over, she want me to come and pay the $705.
All right. So right now your sister has a signature bond through pretrial, but she cannot be released because the Henry County still has a hold. So you can go ahead and do whatever you need to do with Henry County probation. And then
Okay.
Henry County probation needs to send documents to the Fulton County Jail to lift the hold. That's
Okay.
those are the 3 magic words. Lift the hold.
Yes, ma'am.
All right. Thank you. You're free to go.
Thank you.
This is Miss Lindsay Diane Davis, case 24 CR 2292F, accused of battery, family violence from April 25th, 2024. Miss Davis, you've been advised of your right to remain silent, and your attorney is Miss Atay. Any priors, Mr. Howard?
I'm gonna defer to the state. My
Right.
file looks incomplete.
All right. Mr. Graham, if you'd like to touch on her GCIC as well as the state's recommendation.
Yes, Your Honor, I have this as her first arrest. The incident did take place on April 25th, 2024. Law enforcement responded to a domestic dispute. The warrant says 177 Grave Street, but the address where they live is 432 Grave Street. Anthony Applewhite advised that upon waking up in the morning, after being out late the night before, Lindsay Davis was fuming about after having gone through his phone. When he attempted to leave the residence, she began pushing and shoving him, preventing him from leaving. The incident was captured on the Ring video. Once he left the residence, Miss Davis began chasing him in the car, part of which he recorded on his phone. The officer observed scratches on the back of his neck and a bruise on his right arm. A bystander in the area advised that she observed two vehicles, a woman standing outside behaving erratically, a man that appeared to be calm. According to the warrant, Miss Davis's story was a little bit different but inconsistent, and ultimately she was arrested. Our office has made contact with Mr. Applewhite. He says that he and Miss Davis have been together for about 1 year. They live together along with Miss Davis's 16-year-old son at 432 Grave Street. They do not have a domestic violence history. This is the first time that there's been violence. He confirmed the events in the warrant, stated he did not want her to be arrested, and that he does want contact and for her to return to the residence. Your Honor, based on the history and the remarks of the victim in the case, the state is recommending a signature bond through pretrial services, 1-day anger awareness, no further violent contact with Anthony Applewhite, no alcohol, drugs, or weapons. And if we may sound for Mr. Applewhite at this time, Your Honor. I think he is logged in.
Mr. Applewhite,
Yes, I'm here, Your Honor.
raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
So y'all live at a location called 432 Grave Street?
No, the location is actually it's actually 177. It's confusing because there's like a lot next door, and sometimes it gets confusing, but confirming that the actual address is 177 Grave Street.
What is the actual address of what?
Of the home of where we were, or where we live.
So did you call the police?
No, ma'am.
Who called the police?
I think a bystander called the police. I think a bystander called the police, or maybe it was Lindsay. But I didn't call the police. No.
The warrant says that Miss Lindsay Davis called the police.
Oh, well, yes.
Alleging that she was assaulted by her boyfriend, that she was choked and thrown all around the home by Anthony Applewhite.
Correct, Your Honor. I mean, if that's what it says, then that's what happened.
So you're claiming that that's what you did to her?
Oh, no. I thought we were still talking about who made the call.
No, we're talking about what was said in the call.
Oh, well, no, Your Honor, that did not happen. I was not throwing her all over the house.
All right. Anything else?
No, but I just want to say on record that I do absolutely want to have contact with her. I think this was blown way out of proportion. I think that emotions were high. Her and I do not have domestic issues like at all. And we actually do have a great relationship. Her mom lives here, my son lives here, and we have a great household. This just went over the top, and I hate it went that far, but she's not violent. She's a wonderful person. And so I will hope that, I just want you to take that into consideration.
All right. Ms. Atay?
Yes, Your Honor, my client is 35 years old. She is a Georgia resident. She has absolutely no criminal history. This is her very first arrest. She does deny the allegations. The warrant does state that she's the one who called the police. As the complaining witness has also confirmed, they do want to have contact with each other. So I would ask for no violent contact. I don't think the state requested a stay away, but I would object to any kind of stay away. They do live together. Her elderly mother with dementia lives with them. She's 70 years old, and they live with the children. And because of the lack of criminal history, it's her first arrest, I would ask for a signature bond through the jail. And I would object to a one-day anger awareness in this course. In this case, the complaining witness has stated that he didn't even want her arrested. He did not call 911, and nothing further.
Bond is set at 2,500. It's a signature bond through pretrial services, level 1. No further violent contact with Anthony Applewhite. She may return to the Grave Street location. While she's out on a signature bond, she will attend and complete 12 anger management classes. Those classes must begin within 30 days of being released. She must show proof of enrollment in a proper anger management school and to pretrial. Failure to enroll in such classes can result in a pretrial bench warrant. Make sure that you do not consume any alcohol, no illegal drugs, and you're not in possession of any weapons and any firearms. Thank you.
We can go to the wave position, which is position number 8, Kenneth Pack.
Position 8, you say? Oh, okay, yeah. State versus Kenneth Pack. Kenneth Pack is not available. Is there someone else?
No, Your Honor, he's waived, apparently.
Oh, he's waived, sorry. Is there anyone else other than Mr. Pack?
No, besides the add-on SCA.
Okay. Can we address the add-on?
That's the second calendar.
All right, let me just address the add-on first. The Kenneth Pack. This is State versus Pack 24 CR 2251C, accused of criminal trespass, willful obstruction of an officer, and violation of certain rules at a bus, rail, or station, and a PI charge. This all occurred April 24th, 2024. All right, who waived his appearance?
I did, Your Honor.
Ms. Ate, all right. And any priors, Mr.
29. Hold on real quick. 1, 2, 3, 4. He got 4 different open cases on probation in Fulton, simple battery, PI, trespass. You want to know the open cases?
No, I've seen them. Anything
Okay.
else?
Nah.
Okay. Ms. Stafford?
Yes, Your Honor. This incident occurred on April 24th, 2024. Officers arrived at the Peachtree Center station in reference to an unknown male urinating on the platform. When the officers arrived on scene, the defendant was sitting on a trash can on the platform, and when they attempted to make contact, he walked away and boarded the southbound train. When the officer boarded the train, he walked through, the defendant then walked through the emergency doors of the train and went into another train car and sat down. When he was told to leave, he told the officers no. The officer then pulled out his handcuff in an attempt to arrest him, and the defendant then pulled away from the officer resisting arrest. Due to the fact that the defendant has multiple open cases, including a 2023 PI case, the state is currently asking for a $500 surety bond for count 1, $500 for count 2, $1,000 for count 3, and $5,000 for count 4, which totals to a $7,000 surety bond, and to stay away from the MARTA stations, Your Honor.
All right, thank you. Ms. Ate?
Yes, Your Honor, my client is 32 years old. He does suffer from several health and disability issues. He is also homeless. He does deny the allegations as they're stated in the warrant. I think a $7,000 surety bond is, any surety bond is more than what he can afford, Your Honor. He has no ability to pay any kind of bond. I would ask for a signature bond. And of course, I don't object to a stay away from the MARTA.
Right. The bond is going to be a $2,000 surety bond, $500 on each count to stay away from all MARTA property. no illegal drugs, no alcohol, no weapons, and no firearms. And his next court date is going to be May 9th. This is Mr. Pack has been arrested 8 separate times in 2023 in Fulton County Rice Street Jail. And this is his second arrest in 2024, once in January and now in April. So unfortunately, Mr. Pack has demonstrated a very high likelihood to reoffend. Thank you. All right, we have an add-on.
Yes, we can go to position number.
I'm sorry, courtroom 2.
Position number 4 on the add-on, Miss Jacqueline Silva.
Your Honor, may we please be excused?
Yes, Ms. Kim,
Thank
you
you.
are free to go. Thank you. All right, position number 4, Jacqueline Silva.
Second one. Make sure you get all your stuff, and you got some stuff on the desk, so you get what's.
All right, Jacqueline Silva, were the individuals on the add-on just brought into the courtroom?
Heard your announcement, Your Honor.
They were here.
They were here.
Okay. Ms. Silva's case is 24 CR 2353A. Ms. Silva, you have been advised of your right to remain silent, and your attorney is going to be Ms. Abden. She's charged with battery, family violence from April 26, 2024. Any priors, Mr. Howard?
Second, 2022, 2 counts of interference with custody out of Clayton County. That's open.
All right, thank you. Ms. Falk?
Yes, Your Honor. This incident happened on April 26, 2023 at 7:20 a.m. this morning. And officers responded to 108 Park Avenue Southeast in reference to a fight in progress call. They spoke to Mr. Sakanala Saram, which is R-I-R-A-M, who stated that the defendant was trying to rape, hurt, and injure him and their 3-week-old baby boy. He also was concerned that Ms. Silva had a firearm on her. When officers went and spoke with Ms. Silva, she advised that she was postpartum and just wanted to rest. The officers asked if she had any weapons. She stated she did not, and they were able to enter the room and locate Ms. Silva holding the baby in a corner of the room. She refused to give the baby to the officers, and they were having a hard time making sure everyone was okay. At that point, they were left with no other choice than to go hands-on and remove the baby from her possession. She had also bitten Mr. Sakanala on the shoulder, and they were able to medically treat and clear him. He stated that she had the child on the mattress and then went to sit on the child. And then she stated that she wanted to have intimate relations with the defendant, which involved the defendant becoming very upset, yelling, becoming combative, and then eventually biting him. They have been married for about 10 months, and the two of them have been together for about 1.5 years total, and they do share 1 child. There was a question whether an incident had come up before, and Mr. Sakanala said yes. He advised that back in January, he called the police to the same location due to Ms. Silva putting a gun up to his head. So there was some indication of a previous incident involved. As pretrial said, there's also an indication of interference with custody from Clayton County. So we are asking for a $3,000 surety bond on this offense. We're asking for family violence intervention program, a stay away from the address, which is 108 Park Avenue Southeast in Atlanta. No further contact right now with Mr. Sakanala or the infant. We do have some serious concerns about the safety with this child as well as Mr. Sakanala. Given this is the second incident that's occurred in about a 4-month period, it is very concerning. I will state that Mr. Sakanala is here on the Zoom, and we would like to sound for him if he would like to speak at this moment.
Mr. Sriram Sakanala, if you'd like to add to the proceedings, you will need to start your video and unmute.
And Your Honor, we're also requesting that the defendant be in possession of no firearms.
And Sakanala, would you like to contribute to the proceedings?
I had the proceedings, and I had something like she tried to sit on the
No,
child.
no. Would you like to say something?
No,
I
I'm good.
need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Testimony I provide is truth to my knowledge.
Yes or no? Do you,
Yes.
Mr. Sakanala, do you speak English?
Yes, I speak English.
Okay. I'm administering an oath where I'm asking you to speak honestly. So do you swear and affirm that the statements you make are the truth to the best of your knowledge?
One statement I heard is like she tried to sit on the child.
Mr.
That is-
Sakanala, again, I'm going to ask you a very simple question. Are you Indian by birth?
Yes.
Are you from India?
Yes.
All right. So y'all speak English very well.
Yes.
Now, raise your right hand. You're being administered an oath. Whatever you say, will it be the truth?
Okay.
Yes or no?
Yes.
Perfect.
Yeah, whatever. Yes.
Wonderful. Put your hand down. All right. Now your wife is being arrested for battery family violence involving some serious allegations involving a firearm.
Yes.
Are you comfortable with her being near you and your child?
Yes, I am comfortable.
Why
with
is that?
She being here. So like when it happened in January, but she never did that again. And she has been nice to the child, and like she loves the child, so she has been nice to the child. She knows how to deal with the child very well. So I don't have any problems with she taking care of the child. She and I together taking care of the child. And the other thing is I see that she has been going through postpartum. That's why she is like little violent. So I hope she would not in a week or two she would get less violent, and we will be able to stay together.
Okay. Thank you, Mr. Sakanala. You may mute your screen. Thank you. Ms. Abden?
Good afternoon, Your Honor. My client is 35 years old. She's lived in Georgia consistently since 2016. Although she does have strong ties to the community, she would not be able to have anybody bond her out today if not given a signature bond. She has received her master's degree. She was previously working as a teacher and also as an Uber driver. She's currently not employed. As you've heard, she's postpartum. She actually had a baby 2 weeks ago, Your Honor. So she also does have preeclampsia, so she's in a lot of pain right now, and she's not getting the medication she needs at the jail, Your Honor. So I do ask you to take that into consideration today, as well as her familial obligation to the very young child. It sounds like the complaining witness is not afraid of my client and wishes that she return home so they can continue to co-parent. It's my understanding that my client denies these allegations, and she denies these allegations. And so, Your Honor, I do ask that you give her a signature bond so she can return to take care of her baby.
And Your Honor, I just want to point out, this is the second incident since January. My understanding, the baby is 3 months old, not 2 weeks.
Right, but it's my understanding that she was not charged with anything. There's no incident report or police report. This is just the allegations of a witness who's coming to speak before us today. We're also here to decide bond, and he stated that he's not afraid of her, and he wants her to return.
I don't know. It's a typographical error. The warrant says 3-week-old and then 3-month-old. So I don't have any problem believing that it was child's 3 weeks old. Do you have any indication otherwise, Ms. Paul?
No, and I will say I didn't see the 3-week-old. I did see the 3-month-old, so I may have just missed the 3-week-old part. I will say, however, Your Honor, he may say he's feeling fine about it now, but at 7 o'clock this morning, he called the police, told them that she had a gun and she was dangerous and was going to harm the baby, and felt concerned enough to pick up a phone, call the police, and have them intervene.
Understood. Thank you. Ms. Abden, does your client have elsewhere to live? Any other family support?
She doesn't have any other family to live. She also told me that she's really concerned if she does not return home that the child will not be cared for, that the complaining witness cannot do that on his own. And you know, I do understand the state's concern, the court's concern, given the proximity and time to which this happened. But like I stated, this sounds like a misunderstanding, Your Honor. These
I
are
don't
two
think so, Ms.
new
Abden.
parents, under a lot of stress. She just gave birth. I'm just asking to take that into consideration, and the fact that he came here today and testified that he's not afraid of her and wants her to return home.
I can appreciate that, Ms. Abden, but I have to look at the big picture, and the big picture tells me that Ms. Silver certainly needs to get herself in a better shape before she's allowed to take care of the child. There are allegations of violence, allegations of alleged threats, and allegations of a firearm being involved with a 3-week-old child. And that doesn't bode very well for Ms. Silver at the present time. The bond is set at $5,000. It's going to be a signature bond through pretrial services level 3. She's to enroll in a mental health evaluation and submit herself to any treatment within 7 days of being released. Ms. Silva, you are to have no further violent contact with Mr. Sri Ram Sakanala, and no further violent contact with your child. All weapons and all firearms shall be removed from the property and surrendered to the police for destruction. Mr. Sakanala, you are responsible for removing all firearms and taking them to the police authorities to be destroyed. And Ms. Silva will need to provide a receipt of the firearm destruction to pretrial officer within 14 days from today. All firearms are to be destroyed. In addition to the MHET, Ms. Silva is going to enroll in a domestic violence intervention program within 30 days of being released. And Ms. Silva, this is going to be a requirement of your bond that you enroll in these classes. But please remember, you need to go to either your doctor or to a hospital and undergo a mental health evaluation and submit yourself to all treatment and counseling or medication that's required.
Your Honor, would you consider switching the FFIP to anger awareness just because of the cost at this stage?
I was thinking about it, but then the prior incident raised bells in my head, so I'm going to require DBIP. She's not employed at the present time, correct?
She's not, and I'm afraid she's not going to be able to pay for that, Your
They
Honor.
will. He's employed. They will be able to pay for it.
Understood. Thank you.
All right. Mr. Sakanala, do you have any questions?
No, Your Honor, I have no questions.
All right. You got to remember all weapons and firearms must be removed and all guns sent to a police agency for destruction. You must produce the receipt from the police saying that they've taken, or a document that they've taken the weapons from you. She cannot have any violent contact with you and with the child. And she needs to enroll in an MH evaluation with the doctor and enroll in domestic violence classes. And she needs to show proof of this enrollment to the pretrial officer. Failure to do so can have her and return back to jail, and her bond will increase. Understood?
Yes.
All right. Thank you.
This would be per judge.
Yes, sir. She didn't have any priors though, did she? No, she
She
didn't.
got the open interference with custody.
Oh, that's, yeah.
The recommended level was 2 on the report, Your Honor.
3.
Position number 1, Your Honor.
Literally just looked at it.
No, it doesn't matter. No, I'm not saying that's what the recommendation. The court is ordering level 3 reporting.
Yeah, I apologize.
This is who?
This is position number 1.
Okay, DeAndre Berry. Okay.
Barry.
Mr. DeAndre Berry's case is on our add-on calendar 24 CR 2352F. Mr. Berry, you've been advised of your right to remain silent, and your attorney is Ms. Abden. Is that correct?
Yes, Your Honor.
Okay, I'm sorry. Since y'all did this add-on, I'm not certain who's counsel, but is Ms. Abden? All right.
It's going to be me for the remaining add-ons, Your Honor.
Appreciate it.
And me on the other side, Your Honor.
All right. And any priors on Mr. Berry?
I got first.
Okay. Ms. Falk?
Yes, Your Honor. So this incident happened back in March 22nd of 2024, about a month ago. And the officers went out to the location at 2176 Donnelly Hollowell Parkway, apartment 314. They met with Miss Tyra Johnson, who stated that they were in an argument, she and her boyfriend, the defendant. He punched her in the face and the ear while they were in the bathroom. He was leaving the apartment. She was picking up the items he had dropped on the stairwell. He turned around, punched her, causing her to fall on the stairwell, and then repeatedly jumped on her head and body while she lay on the floor. They do share a child together and have been in a relationship for about over a year. The officers met with Miss Johnson in the emergency room where she was being treated for swelling to her head, face, and had blood around her left ear. I did have an opportunity to briefly speak with Miss Johnson, and she is here today. She does not wish to proceed. However, the state is pretty concerned by the level of violence that was employed in this particular case, as well as the fact that Miss Johnson did need to be treated at the hospital. She says that the swelling has subsequently gone down and she no longer has the physical injuries, but I am quite concerned about the level of violence that was employed in this particular case. The state's recommendation is going to be a $2,000 surety bond. We are asking for no further violent contact with Miss Tyra Johnson, as well as FVIP, and no firearms. Miss Johnson is here and we would like to sound for her at this time.
Ms. Johnson, if you'd like to contribute to the proceedings, you'll need to unmute and start your video.
Yes, ma'am.
What are you wearing?
I have on a brown, it's a dress. I have on a dress.
All right. Ms. Johnson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. This looks pretty serious. How old is the child now?
My baby is 7 months now.
Okay. And what would you like to tell the court?
I would just like to tell the court that we actually have a great relationship. I just think things went a little far left that day. He's a great father. He helps me with my son. That isn't his son, but he helps me with him. He raised his daughter. He has 2 jobs. Like he does the thing. I'm sorry.
So the young child is not his?
No, my daughter is his, but I have an older son.
Oh, I see. So you share one child with him?
Yes, ma'am.
And how old is that one child?
My child is 7 months.
The daughter?
Yes.
Okay, that's what I was trying to figure out. Okay.
Yeah.
And were you taken to the hospital on that day?
I went to the hospital on my own because I didn't get any, no police came, no ambulance came, nobody came to help. So I went on my own. When I got there, they told me the severity of the situation. And even then I didn't want to press charges. I just wanted to be treated because I didn't know if I could be, if like something worse could happen in the situation.
What do you mean worse?
Like I was bleeding from my ear, so I didn't know like if I could go deaf or anything like that. So.
And what if something worse had happened?
Then it'll be a different situation.
How would it be different?
I would have to be mature and I would have to be mature and put things in perspective and do what's right for me and my children.
Thank you for that. Appreciate it. Thank
Yes,
you.
ma'am.
Miss Abden?
Thank you, Your Honor. My client is 21 years old. He has lived in Georgia his whole life. He has a lot of family in Georgia. He does have strong ties to the community. As you heard, he does work 2 jobs. He works as a security guard and a cook. He said that both children are his. He does consider them his, and he's been taking care of them. I understand the allegations are concerning, Your Honor. However, as you've heard, the complaining witness is not afraid, does want him to return home. And she even said herself that if this was a situation where it was necessary to protect herself and her children, she would. And she chose not to do that. It's been about a month since then. It sounds like there have not been any incidents since. And so I do ask that you take that into consideration and that you grant him a signature bond, no further violent contact, and to return to his home. And that is all.
Okay. Domestic violence is a very strange creature because when those kind of cases come about, it really isn't the victim's decision whether to press charges. It's completely up to the prosecutor. And sometimes the prosecutors don't even need the victim's statement. They can look at all the other evidence to decide whether they want to move forward with the case. And unless I hear from the prosecution saying they're willing to drop the case, right now, what I see is something of great concern to me. On DeAndre Berry, his bond is going to be set at $3,500. It's going to be a signature bond through pretrial services. Mr. Berry, you will be released on a pretrial bond, and it'll be a level 2. That means you're reporting to pretrial twice a month. This is not a conviction. This is a condition to your bond. This is still an open, active case against you. You are to have no further contact with Tyra Johnson. You are to stay 200 yards away from her, not communicate with her in any way, form, or manner, with one exception. You can have visitation with the child that you share with her through a third party. So there can be third party transfer. In other words, you can co-parent, but there must be a third party to pick up and drop off the child so that you can see. You are not to return to the 2176 Donald Lee Hollowell Parkway, apartment 314. You're to stay 200 yards away from that location. If you have personal belongings, you can return to that location one time only with a police officer to retrieve your belongings. But after that, you're not to return to that property. No alcohol, no illegal drugs, and no weapons and no firearms. You'll be subject to random screens by pretrial. Also, while you're out on a signature bond, you will enroll in a domestic violence program, and you must enroll in that program within 30 days of being released. So by your 3rd visit with pretrial, you must show proof that you have enrolled in such a class and that you will continue to attend those classes until they're completed. Thank you.
We can go to position number 2, Mr.
Alcaro?
Yes, Alcaro.
Thank you.
Your Honor, I don't think I received information for this one. I have 4.
Okay, this is Alcaro Greer. He's got 2.
Oh, Greer. Apologies.
Yes, Greer had 2 separate cases, but yeah, I did send Miss Abden both of the warrants on both cases.
It's 2. I apologize. Thank you.
He is position 2 and 3. Sorry, Your Honor.
That's okay. I knew what you meant. Okay. Mr. Greer has got 2 separate cases. The first one is 24 CR 2351H. The second one is 2355H. In 2351H, he is accused of, and that we criminal trespass from February 12th, 2024. In the subsequent case, 2355H, he's accused of criminal trespass, terroristic threats and acts, and willful obstruction of an officer from April 25th, 2024. Mr. Greer, you have been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Abden. Mr. Howard, any priors?
13. He had a trespass arrest from this year. 2023 trespass damage that was dismissed. 2022 FTA probation. 2021 probation. 2020 FTA. 2019 burglary first degree. He's on first offender probation for that. And a 2019 FTA.
Thank you. Ms. Falk?
Yes, Your Honor. The first case involving the criminal trespass was on February 12th of 2024. The defendant was in the Marquee Midtown Apartments. He was in a vacant apartment. The security officer, Thomas Powell, advised that it was a vacant unit, not supposed to be operated by anyone. The officers went inside the residence, in about 45 seconds of giving verbal commands, the defendant appeared with his hands up. They also spoke to Mr. Antonio Hull, who stated that he had just changed the locks on the unit earlier today due to finding multiple items inside of the unit. And he did speak to the defendant previously and advised him to no longer come back to the property. He stated that it was his third encounter with the defendant after being told not to return, and the defendant was placed under arrest for this criminal trespass. The second case actually happened yesterday at 4:20 p.m. That incident happened at Core at Lindbergh Apartments, 741 Morosco Drive. In that case, they spoke to Mr. Keontae Jenkins, who was the property manager. She stated that she needed to remove him from the area, the defendant from the area, because he had his things spread out in the space. He was, I do not believe he was a resident at that location. He started yelling at Mr. Jenkins when Mr. Jenkins tried to get him to leave and threatened to F Mr. Jenkins up. At that point, the officers went to the location, told the defendant to turn around and put his hands behind his back. He refused to comply with the instructions of the officer and then ran out of the building. At that point, he was caught by the officer and placed under arrest. So as you heard, the defendant's history is littered with criminal trespasses, and he's currently on first offender for burglary, which is why we were hesitant to give any sort of signature bond on this case. Our recommendation on the first case, which ends in 351, is going to be a $500 surety bond. We are going to ask that the defendant stay away from the location, which is going to be the Marquee Midtown Apartments at 415 Armour Drive Northeast in Atlanta, Georgia. On the second case, we are going to ask for a $500 surety bond on counts 1 and 3 and a $1,000 surety bond on count 2. We're also going to ask for a stay away from that location, which is Core at Lindbergh. That address is going to be 741 Morosco Drive. And we are also going to ask for no further contact with Keontae Jenkins, no alcohol, drugs, or weapons. That's all for the state.
Thank you. Ms. Abden?
Thank you, Your Honor. My client is 30 years old. He lived in Georgia his whole life, does have family here, so he does have strong ties to the community. He does deny the allegations in both cases, Your Honor. It's my understanding that there is some MH, and I have he's agreed to speak with one of my social workers, and I will connect them. However, that is not the basis of this case, and I do not have any competency concerns at this time. As I stated, he does deny the allegations. I do understand that he does have a history. He's currently not working at this time. He does have a place to live. He provided an address to me, and we will be representing him moving forward. And he's also promised me that he will return to court for his next court date. So I understand he does have a criminal history, but I am requesting a signature bond, Your Honor.
Understood. Thank you. On the first case ending in 551, that's going to be a $500 surety bond. Did I give the correct, excuse me, 2351H. That's going to be a $500 surety bond. Stay away from the Marriott the Marquee Midtown Apartments at 415 Armour Drive in Atlanta, Georgia. And the second case ending in 2355H is going to be $500 each on each misdemeanor offense. So that's going to be a $1,500 surety bond. His total bond is going to be $2,000 surety. He's to stay away from Core Apartments at 741 Morosco Drive in Atlanta, Georgia, and have no contact with Kayonte Jenkins. Both cases, no illegal drugs, alcohol, and weapons, and his next court date will be May 9th. Thank you.
Thank you, Your Honor.
Next, we go to position number 5, Mr.
Jaquarius Winters?
Yep, that's him.
All right. Mr. Jaquarius Winters is accused of theft by taking and criminal trespass, 24 CR 2354E. Mr. Winters, you've been advised of your right to remain silent, and your attorney is Ms. Abden. Any priors, Mr.
16. You got an open loading problem, trespass. 22 CP 209008. Got another open case, theft by possession of stolen mail, 23 CP 217491. On probation in state court for shoplifting and trespass. You want a case number?
Yes, please.
23 CR 002890E. He got 12 months back in January. Also on probation for felony shoplifting, 23 SC 189251. He got 2 FTAs from this year's 2023 probation FTA, 2022 trespass, and 2016 FTA.
Thank you. Ms. Falk?
And Your Honor, the defendant's history is the reason why the state couldn't bring myself to make a recommendation of anything other than a surety bond, being that he has several open probation cases, has several FTAs, and I just have concerns that he is going to be a repeat offender as well as someone who is not going to appear in court when called. In this incident on April 25th of 2024, the defendant went to Shannon Littlefield's property at 130 Creekmont Way in Roswell, Georgia. The officers, Miss Littlefield actually saw on her Ring doorbell the defendant stealing her lawnmower off of her property. And then the officers reviewed the Ring doorbell and witnessed the defendant enter into her property without her consent, walked on the front yard, took her lawnmower. They also met with Jennifer Miles, who stays with Mr. Winters at 170 Creekmont Way. So he is neighbors with her, and stated that he was not currently at the property. And she had also witnessed the defendant bring the lawnmower onto 170 Creekmont Way, where she resides with him. She also verified for the officers that it was in fact Mr. Waters on that Ring doorbell camera. And so for those reasons, the state's recommendation is $1,000 surety bond, $500 on each charge. We are also going to ask that he have no further contact whatsoever with Shannon Littlefield, and that he stay away from 130 Creekmont Way in Roswell, Georgia. No alcohol, drugs, or weapons. We'd also like to ask for an anti-theft course given the defendant's history. That's all for the state.
Ms. Abner?
Thank you, Your Honor. My client is 30 years old. He has lived in Georgia his whole life. He does reside at 170 Creekmont with his girlfriend and their roommate. It's he does deny the allegations, Your Honor. He states that he was given permission to borrow the lawnmower. It's my understanding that his house recently burnt down, and that he was told by his girlfriend and the roommate that he can just go grab it, use it, bring it back, Your Honor. I do understand he does have a criminal history. From what I can tell on my end on the pretrial report, none of these cases that are open are violent. And so I am asking you to take that into consideration. He states that he is working, but his indigency is still a concern. He works at the Fulton Metal Recycling, and he also does some odd jobs over the weekend, but he would not be able to afford any bond. And he has assured me that he will return to court, and he does qualify for our services. So I am asking for a signature bond, Your Honor.
All right. Bond is set at a 1,000. It's going to be $500 on each count. That's a total of $1,000 surety bond. Next court date is going to be May 9th. To have no contact with Shannon Littlefield and to stay away from 130 Creekmont Way in Roswell, Georgia. Miss
Shannon Littlefield, that's not the owner of the lawnmower. That's
You're-
the property next door.
Mr. Winters, I'm going to advise you to exercise your right to remain silent. Anything you say.
I have to check in for my probation. I'm already in the anti-theft. I've already taken the anti-theft course. I've already done, I'm enrolled in college. I'm doing better. I haven't even, I paid my probation fees for Roswell and I've showed up for all my courts. I went to my court and my lawyer, she got all of my FTAs and she put them together for me. Like, I can't afford it right now. I have child support. I have a 3-year-old kid that I have to pay child support for. I can't afford it. If I could just get a signature bond so I can pay my child support and go to my probation, I'll report. I'll do whatever I have to do to make sure.
Mr. Winters, the judge has made her ruling and anything you say can be used against you. So I'm going to advise you to exercise your right to remain silent.
Like, I'm doing the best that I can with what's that. I made a lot of mistakes in my past, but I'm doing the best that I can to fix them.
Mr. Winters, I understand that.
They allowed me to borrow the lawnmower. I'm friendly.
I wish I had someone from that warrant to come here to verify that. I don't, all I see.
But if you could just give me a signature bond.
Mr. Winters,
you don't qualify for a signature bond. You don't qualify for a signature bond.
How do I not qualify?
Because of your numerous convictions, the fact that you have open probation cases,
But
and you're asking me and I'm trying to answer. And the fact that none of your alleged defenses are corroborated by any of the information in the arrest warrant. The arrest warrant simply says that not only Miss Shannon Littlefield, but also your roommates saw you removing this lawnmower from someone else's property.
Your Honor, like I stated, he did that. He just thought he had permission to do it.
Understood, but the permission part is not corroborated by the warrant.
Just wanted to state that for the record.
Yes, understood. I understand his defense. All I'm saying is that
Jennifer Miles and there's no Waters. There's Jennifer Wilkie and there's Jaquarius Winters.
Mr. Winters.
That's my ruling. We'll see him on May 9th. Thank you. Okay, Deputy, I think we're concluded with the calendar. I'll just go over the cases. On the add-on matters, position number 1, that's going to be a 3,500 signature bond through pretrial level 2. For Alcaro Greer, he has $500 surety on first case and $1,500 surety on the second case. Reset date May 9th. Position 4, Silva, that's a $5,000 signature bond through pretrial level 3 with an MHET and a DBIP. By the way, position 1 is also required to do a DBIP.
Hey, what's that contact on 1?
No violent contact with the spouse, Srinam, and the minor child. Position 5, Jaquarius Winters, $1,000 surety. Reset date May 9th.
I was showing no further contact with Tyra Johnson on number 1.
Yes, it's no contact with Tyra Johnson to stay away from the Donald Lee Hallwell location. Third party transfer of the child, FVIP.
Okay, thank you.
Okay, now on the regular calendar, position 1, Adams is a 3,000 signature bond to pretrial level 2. Position 2, Bader is a $2,000 signature bond to pretrial level 1. With okay. Position 3, Brown is a $1,000 signature bond. I can't recall whether I did it through the jail or pretrial. I think it was through pretrial.
It was
What
a
number?
jail, Your Honor.
It was a jail? Yeah.
Yes.
All right. Yeah, that's okay. Position 4, Davis was a 2,500 signature bond through pretrial. That was position 4. Position 5, Jefferson is a $10,000 signature bond through the jail. This is a Riverside matter, but in accordance with the Superior Court order, he's required to stay away from the alleged victim, Mr. May Johnson, I believe. Position 6, Lawana Johnson's a $2,000 surety bond. No, sorry. Our case for battery, she's got a 3,000 signature bond through pretrial level 1, but she's got the other case 19 CR 007731, in which she has a $2,000 surety bond. So we're going to reset both cases to May 9th. Position 7, Ogletree is a 1,500 signature bond through pretrial level 1. Position 8 is a $2,000 surety bond, reset May 9th. Position 9, Robinson is a 2,500 signature bond through pretrial level 1. Position 10 is a 2,500 signature bond through pretrial level 2.
Hey, what's the contact for 9?
9 is no contact with Cheryl Brown.
And that was level what now?
Level 1,
Level 1.
no contact, and to stay away from 899 Park Street unless she has vacated the premise. I don't think she has. So, all right, going back to, I think we got position 10. Position 11 were Carolina Williams is a 1,500 signature bond pretrial level 1. And she may be released only once her hold is resolved. I guess she's got a probation hold from Henry County, according to her sister.
Judge?
Yeah.
On position number 6, was there a stay away?
666. This was Lawana Johnson, and yes, this was a this was a no contact with Pralethea Westfield.
Okay, and no.
I don't know if that was a stay away. I don't think so.
I don't think so. I
Yeah.
want to make sure. Thank you.
Any other questions, folks? No? All right, everyone. Have a good weekend. We'll see you next week. Thank you.